Okay. All right. So are you Kendrick O'Veal?
Yes, ma'am.
You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third-degree felony. So
here's where the legal stakes start escalating. Those prior convictions aren't just background details. They dramatically increase the potential punishment. In criminal law, this is called sentence enhancement. Essentially, the justice system treats repeat offenders more harshly, meaning past crimes can transform what might be a smaller sentence into something far more severe.
September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then, in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is...
This charge is particularly serious. In many states, once someone is convicted of a felony, possessing a firearm becomes illegal. So the big question for the jury, if this goes to trial, will be simple but critical. Did the defendant knowingly possess that firearm?
From August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or the rest of your life. Do you understand? And then finally...
Did you catch that? Habitual offender status changes everything. The minimum sentence jumps all the way to 25 years, and it could go as high as life in prison. At this point, the courtroom isn't just discussing charges. They're discussing the possibility of spending the rest of someone's life behind bars.
Finally, in cause number 25 DCCR 1778, once we get all these done, you're charged with a third-degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases I have here on this tablet,
Now comes the moment that often determines the direction of a case, the plea deal. Prosecutors frequently offer a reduced sentence to avoid a long and expensive trial. But accepting it means admitting guilt, while rejecting it means rolling the dice with a jury.
A plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in...
It's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is ahead of...
Oh, I opened the wrong one. Sorry. Hold on. Y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all 3 cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you?
Yeah.
And so you have every right to reject that offer and have all 3 of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that?
Yeah.
And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oakville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oakville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Negative.